Welcome to A Lawyer's Guide to the Galaxy, a podcast about geek culture by lawyers, with your hosts, Ben Siders and Kirk Damman.
This episode is sponsored by the Camino Bureau of Tourism. Once you visit, a part of you will always be here.
And welcome back to the Lawyer's Guide to the Galaxy, Season 2, Episode 2, with your host, Ben Siders. That's me, and the other guy is Kirk Damman.
That's Kirk, as in the captain of the Enterprise.
We are intellectual property lawyers and certified geeks practicing law in St. Louis. For those of you who may be new to the show, the recipe is very simple. We start with a dough of interesting questions about geek topics, add a pinch of law and policy, bake at the temperature of this recording studio for about 1 hour to create a flawlessly balanced conversational souffle, consisting of really no answers and usually more questions than we started with.
And garnish and repeat.
Garnish to taste, yeah. You can find this podcast on Twitter at LGGPod. You can find me, Ben, at Benjamin Siders. You can find Kirk at KirkDMN. We're back.
We're
again.
back.
We survived.
This is our sort of, second part of our rebooted second season. We did get renewed. I think that's, a big thing in conjunction with it. So if obviously any sort of new listeners, there's an entire first season out there. We didn't start last episode.
We need to start our renewal negotiations earlier in the prior season next time.
Definitely. I think that's, one of the issues. And that's, one of the things that I was just going to mention sort of, quickly here, I think in conjunction with it is as part of, sort of reboot coming around with this, we know we have a bunch of content coming. It's allowing us to set up some stuff for, sort of known things we can do this season. So that's helping. And we should have some really interesting topics coming up. But obviously a lot of it's going to be just when can we get guests in, when can we get stuff scheduled, things along those lines.
Yeah, this season's going to have some scheduling and coordination challenges that we didn't really have much last season. We only had, I think, one guest last season. Charlotte came in.
Made Charlotte come in.
Which was a big hit. You all seem to like that a lot. So we're going to try and get her back because she's a crowd favorite. And we've got some other folks in the pipeline, too.
That we're definitely looking at. And I think that's the goal for where this is going. We definitely, we know you guys seem to like guests, seem to like discussions on other topics other than just listening to us.
Yeah, they just started listening to us, that's all.
Yeah, exactly.
Let's talk about AIPLA real quick. Kirk and I both were out in D.C. Some of you who are listening maybe met us while you were there.
I know we got a couple subscribers out there, so maybe you guys are listening to this as your first new episode that'll download it since you started subscribing.
Thank you and welcome. One of the things that I thought was interesting, Kirk, you and I both attended the Copyright Committee presentation on day 2 on Friday. And part of that presentation was really a couple interesting parts. One was an attorney who was involved with the Star Trek Axanar case. I never got clarity on which side of that he was on, but he was involved apparently. Talked about some of the issues with fan fiction, which has also been a crowd favorite topic here. And then we also had one of the lawyers in the Google Books case talking about fair use. And between the two of them, they covered a lot of the cases we talked about back in our character copyright episodes.
Yep, way back in season 1.
Yeah. This last spring, which I don't know if it's a coincidence or not, but those episodes have recently gotten a lot of downloads, more than they got at the time. So I thought that was interesting. So we're talking to some of those lawyers we met at AIPLA. A few of them have expressed interest in potentially being on the show and talking about some of the interesting work they've done. So that is another one of the future guest appearances that we may have.
Yep.
We hope. Also, I don't know if it was before our last episode, the Music Modernization Act passed. And I think, did we talk about this last time?
We talked about it briefly.
Yeah.
Definitely, sort of just gave some basic overview as to what it was. I'm not sure we gave a lot of detail.
Yeah, we did a client alert through the firm we work for, and that actually got more feedback than what we usually get, which is by itself impressive. So I thought maybe we'd do just like a 2-minute summary of like what it is for those of you who are interested in music law. It's really a big deal. Like our music laws have not substantially changed since really the 70s.
1970s-ish is sort of the last change.
Like
that wasn't a major change. There was a lot of stuff that was important in that.
72 was really the big one, right? Because in 72, the federal government for the first time recognized federal copyrights in songs, recordings of songs. Yep. Songs themselves were already covered back since the 1830s.
Yeah, we had the Digital Millennium Copyright Act sort of since then, but I think that's in some sense not been as important to music as to the internet.
They had DART, which was legislation to kill the digital audio tape.
Inadvertently, yes. Anyone who's never heard of digital audio tape, you can thank the U.S. Congress for that.
So it's funny, when we did the committee meeting after the actual presentation, presentation, one of the general counsels from the Copyright Office was there. She's kind of going through like a list of what the office is doing this year, and one of her bullet points was clearing out the DART fund. And everybody in the room kind of looked around like, what is that? I was like, oh, I know, I've heard of this. It was like 8 cents in there? Like, how much can that be?
Yeah, seriously. And the thing about it is, I think that's the thing with to really talk about with the Music Modernization Act and what happened. We've as much as we pick on copyright in this show and sort of, problems with copyright and things like that, the reality of it is that the copyright laws have not been sort of well harmonized with each other. We have issues internationally, but they haven't even harmonized essentially in the United States with each other. And part of that's because we've had extensions happening piecemeal. We've had kind of these, major changes to copyright law that don't change everything. They first acknowledge this is copyrightable. But you bump into things that, what happened to things that have already expired? And, how do you deal with, hey, if we're going to, grant this sort of retroactive thing, what does that mean for people who didn't do what they were supposed to do previously, but now would normally be granted retroactive? I'm thinking of the fact of a lot of copyrights had the question of would you correctly provide notice, which used to be an issue. Then they said it wasn't. And so the issue with it is if it comes back and says, well, now it's not. Well, what if you hadn't done it before they changed the law? How does that retroactivity work? And what you really bumped into, and I think the biggest issue in a lot of what the Music Modernization Act was trying to deal with, is just simply how do you deal with these things when you're either a copyright holder trying to do what you're supposed to do, or more particularly, you're somebody who wants a license to a piece of copyrighted work, in this case, music in particular, that's trying to do the right thing and just plain can't figure out what you're supposed to do.
Well, along those lines, so this is something I was thinking about over the last week, and I've not run this by Kirk yet, so I'm going to give this thought to him cold. Is it just me, or does it seem like the Copyright Act, our three major IP acts, the Patent Act, the Trademark Act, also known as the Lanham Act, and then the Copyright Act. The Patent Act, to me, is, except for maybe pharmaceuticals, written in a relatively technology-agnostic way, wouldn't you say? Yeah,
I think it's very true. I think there's specific stuff with interaction, not even just pharmaceuticals, but interaction with the FDA, and sort of a recognition that you have a second regulatory body that's a very active regulatory body that has a lot of effects on it. And particularly when it comes to things like generics, they essentially require people to admit to patent infringement in order to approve them. And so you kind of bump into this scenario that says, hey, you need to have some recognition of how these two things interact and what the deal behind it is.
But there's not like, well, here's how we do software, and here's how we do mechanical, and here's how we do chemical. And it's just, other than some extra regulations that apply to certain things that are basically medical therapies used on humans.
And stuff like covered business methods, which is subject to only certain parts of the patent law.
So there's a couple things, but it's not pervasive, right? You're not going to have a whole separate section on music recording technology, for example.
Yeah, you really don't have this sort of splitting apart.
Although within the patent office, that happens administratively, but it's not part of the law itself.
Yeah.
And then trademarks are the same. There's famous marks and unfamous marks, and otherwise not a whole lot of distinctions amongst categories of marks. Yeah. Some special things, for certification marks, but they're not going to treat, automotive different than
a little bit of differences on specimens and examples of use for stuff like service marks versus goods marks, things like that. But I think when the idea of saying automotive marks are different than PC marks, which are different than bread marks,
the substantive laws basically, there's not like a whole lot of extra provisions. But then you turn to music.
Well, you turn to copyright.
Or copyright, where music in particular has an enormous amount of European style legislative content explaining how it works, all these compulsory licenses, and more so than the other industries. I mean, can you think of another act that will specifically say this definition means ASCAP, BMI, CSAC, or an equivalent organization? The copyright rules, perhaps ironically, even more so than the patent rules, really feel like a legislative response to changes in technology.
Yes.
Which kind of seems non-intuitive because patents are supposed to cover technology, not copyrights. But the technology drives, what we want to protect and how we want to protect it. And those changes going back to the printing press, we only have copyrights because we have a printing press.
Yeah.
If we didn't have printing presses, we wouldn't need this idea at all. So when you look at the Music Modernization Act and its antecedents, it just feels like copyright is much more industry specific. And since the legislation is responsive to changes in industries, it seems to track that more closely.
Yeah, I think the thing you really see in copyright, and I think a lot of it also is copyright has a lot of sort of interacting interests, which you really don't necessarily see as much in patent. Again, you can look at it and say like, okay, there's interacting interests in pharmaceuticals, but those interacting interests are between two different organizations, between the FDA and the patent office. In music, you have the idea of sort of the copyright holder looking at it and saying, well, who is the copyright holder? And sort of the generation of these works requires multiple people. In patenting, it's just, okay, these people are all inventors. They're all literally treated the same
company. Yeah, take like a movie or a video game.
Yeah.
The number of different independent contractors and voice actors and models and people who don't all work for the video game company that get involved, as compared to, if you're an inventor working for, I don't know, a pharmaceutical company, you're probably just a chemist or a biochemist on the staff, and you work and research and I think maybe it's because the licensing and the transfers of ownerships are different. So, for copyrights, we have, I think, a more acute need to do lots and lots of licenses to small works. Like in music in particular, if I'm going to run a radio station, I need these rights to all these different things.
Yeah, to every different song I'm going to play, which is hundreds.
Yeah. Whereas, other than like patent trolls, there's no mass patent rights licensing entities.
Yeah.
They just don't exist.
Yeah, because nobody needs, for the most part, licenses to 100 different patents owned by 100 different entities.
Yeah.
Whereas a radio station is going to encounter that every day.
Yeah. So we're probably running long here in our introduction, but it's interesting. These copyright is sort of the redheaded stepchild of IP. The real IP lawyers don't take it that seriously.
You hear hard and soft IP. That's a phrase that gets used a lot.
But the legislative changes get a lot of attention, I think, because they are so industry specific, and I think more understandable and accessible to everyday people.
Well, I think part of it's also just, and we've said this before, people encounter copyright daily.
Yeah.
The odds of you bumping into a patent, requires you to usually have a product and notice that it's patented.
You're experiencing copyrighted content right now.
Yeah, exactly. Unless you're, building something or things like that, your odds of really interacting with patent are relatively small, whereas your odds of interacting with copyright, you turn the radio on in your car and you're interacting with copyright,
Anyway, so how about some legal news and goings-on? A couple things I just kind of saw this morning on the way over here. One, did you hear about this? There's an injunction issued for a cheat program in the Grand Theft Auto. I guess there's a Grand Theft Auto RPG now, like an online thing. I've never played it, so I don't know.
Yep.
But somebody made a cheat module that would basically modify the client, I think, to arbitrarily inflate your statistics and make it easier to grief other players. And then Take-Two sought a preliminary injunction, and they got it to block the cheat program.
Okay.
So that's one of those rare cases where I think we look at it and say, well, yeah, that's probably how it should have happened. There's also a BitTorrent case that I thought was interesting because it did not go the way I expected. So a guy in Oregon was accused of infringing a video of some kind. It was like a magic, how to do magic or something like that. But the complaint that was filed by the copyright holder to the video basically said, we've traced the IP to, or the source of these infringements to this IP. It's this associated with this subscriber at this house in Oregon. So either he did it himself or he was negligent in managing his network and allowed somebody else to do it. And then the court dismissed it, saying that was not sufficient facts to state a claim for copyright infringement.
Yeah.
Which it's a really low hurdle to be able to state a claim. I mean, that's hard to not do. Not only that, they had a chance to amend and still didn't remedy it, and then they had to dismiss, and the court ordered the defendants legal fees paid of $17,000.
Yeah, it's an interesting case. I think a lot of what probably came out of this is it's securing your Wi-Fi to prevent others from infringing. I have no obligation to secure something to prevent others from infringing. We think that's the next logical conclusion. That's saying that a library has to secure the photocopier in the library to keep others from photocopying books. I mean, you can't make a claim.
That's really what this says, too, because the standard for a motion to dismiss for failure to state a claim is, even assuming all of this is true, you still haven't said enough to prove that you could possibly win this case. So they're saying even if he should have but didn't secure his network, that's not the basis for claiming he is somehow liable for direct or contributory copyright infringement. That's a big holding.
Yeah, and quite frankly, I think it's right. I mean, and the reason I think it's right is because I think the idea of saying somebody needs to secure their Wi-Fi or else they're, legitimately caused by it, that's a legislative action. That's not something that can basically come out of a court saying
the court's not going to manufacture a common law, negligence duty to secure your networks for people who don't know how to do it.
Yeah, and again, I think that, you talk about that's like saying, you have an obligation to secure something else. You have an obligation to secure the company photocopier so that people don't. You can take this to the next level's extreme of saying, what do you mean to secure so that somebody can't use it for infringement? You can take the other direction as well, and you say, hey, even for securing a Wi-Fi, does that mean if I get somebody illegally hacking into my network, to now distribute child porn, I'm still liable for it?
Yeah, that seems very wrong.
That seems very wrong in the way the thing goes. And so I think the real problem here is that they didn't say he did it, and they really couldn't say he did it. It was either he did it or somebody else did it.
Yeah,
without his knowledge.
They needed more pre-rule. What is it? Rule 26. I forget the conferences you have to have with the court. But there's a conference with the parties that you have to schedule, and but before that, you can conduct some discovery. They really needed to do more to establish this connection. They didn't do it. Yep. Also interesting, Kirk. Do you remember Mana Mana?
Man.
If you don't remember Mana Mana, just Google Mana Mana and Muppets, and you'll find it. It was a Muppet song, and I think the very first episode of the Muppet Show that was revived when they redid the Muppet Show in the 90s. There's actually a dispute over the copyright to that song. I didn't know any of this background. Apparently, the song was written for a 1968 Italian film. And on a side note, I'm trying to imagine what movie would use that song.
Probably the Muppets.
Yeah. But the composer apparently wrote the song, and the movie studio sued for copyright infringement in the U.S., I think in the U.S., and it was dismissed for lack of standing on grounds that the contract between the composer and the movie studio didn't clearly enough, satisfy the court that the studio actually acquired from the composer the copyright rights, and they had the same analysis whether under U.S. or Italian copyright law. So this one's just interesting because we see this a lot just every day in our careers. Unclear documents where people go and find some Franken contract online and say, I don't need a lawyer, I can just do this myself. And then a year later, you get something like this where had you just written it properly in the first place, this wouldn't be an issue. Yeah,
it's a really interesting thing. I think it's a really good sort of point to point out is that a lot of times people, when they have copyrighted content and stuff like that, they're not looking at this as being valuable. It's the thing where there's huge amounts of songs written every day, 99.9% of which nobody will ever hear. And so I think there's a big feel of like, oh, I just wrote this little tiny thing.
Yeah, it's never going to matter.
It's never going to matter. And then you bump into these cases where something takes off, becomes viral, whatever it is, in sort of today's world. And suddenly it does matter. And, you didn't put the pieces in the places you should have earlier. And now you're coming back saying, hey, we want to try to put back what we intended this to be, with really no records of what you intended this to be.
Or you have a document and, you say, well, I don't need to make this that clear and explicit in here because we all know each other, we get along, and we're good friends, and, we all know what the deal is. Well, but, this is 1968, 50 years later when we're fighting about it.
What was the deal? Yeah.
What was the deal? And is everybody even still alive to say what the deal was? So there you go. And then finally I saw, I think you may have sent this to me, someone did, that the Disney character case we talked about with the characters made for hire, that case is moving forward. I think it's been narrowed, the scope of the issues, but it is proceeding. So there you go, some legal news. We got to check on that Sabak case and see what's happening to that too. I meant to and I forgot. Well, anyway, so today's topic is going to be a little different. We're going to talk mostly about rights of publicity, and we're also going to get into a subject I don't think we've ever discussed before, which is price fixing.
Yeah, which is an antitrust concept.
Yeah, antitrust. And the lens through which we're going to examine this is a video game. Happens to be a sports video game, but don't let that turn you off if you're not into sports. Because I am into sports, and I have never, ever played any of these games. Yep. I've seen them. I know what they're about. But actually, take that back. I've played the NHL version a couple years ago. But I
believe I played some NASCAR versions.
Yeah, probably. So the background of the game is from, starting in 1993. I'm sure you've all seen the EA games. The Madden game comes out every year. There's an NBA 2018.
Yep. They even use it to predict the football outcome. They have the computer play the computer and see what the football it predicts for the Super Bowl outcome.
Yeah, they'll put the AIs in charge of it and just see who wins each year to compare that to the actual outcome. So these are very famous. I'm sure you see the ads. I don't know what EA, it's in the game. I don't know if that's what they do now, but it's what they used to do.
What they used to do. That's not trademark infringement, was it?
No, nominal fair use. So they started making an NCAA version of this in 1993 that used the college football teams that everybody knows and loves. And the game allowed players to be their alma mater or whatever team they wanted. There's all kinds of different modes. And one of the things that this whole line of games really tries to capture is accuracy. They want it to really look and feel like the experience of coaching these teams or playing on these teams. I mean, just like to some extent, like an online RPG would, you want to really feel like you're stepping into this world, just for a little bit. It's escapism, just like all the rest of the escapism that we really like.
It's Dungeons and Dragons for sports fans.
Yes. But one of the problems with NCAA is that, college athletes have this amateurism principle. They can't be compensated for the use of their names and likenesses. So, and they get in trouble for that. It can render them ineligible for their scholarships or to play and so forth. So, to sort of get around this, EA would include the players in the game. So let's say we had our NCAA football game from 2010. Yep. Well, then all the teams that were eligible for Division I football in 2010 are there, and the players,
at least all the ones anybody cares about to play.
And the players, the jerseys are accurate and correct. The logos are correct. That information is all licensed from the universities through a collegiate licensing collective. I have the name in here somewhere. Collegiate Licensing Corporation is the mass rights. It's sort of like an ASCAP for college licensing. So the stadiums look the same, the cities look the same. They sort of like mimic like it's a broadcast, and the rosters are the same. So if you've got 87 players, then those numbers are all in the game for that year, and it's got biographic information about each quote unquote player. Although there's no name, it just says player number 77. Yep. But the player's height, weight, skin tone, appearance, build, all that matches whoever wore number 77 for that team for that year. Down to the point where EA would actually send surveys to equipment managers for teams asking what type of equipment each player wore, what style of face mask. They can make it all as accurate as possible. And, as we'd expect, Kirk, someone got paid for all this. Yeah. The schools. Through the licensing collective.
I think it's also important to note, and one of the things you mentioned, it wasn't just the equipment that they wore. They did also get basic, demographic information about the players themselves.
Yeah. Height, weight, hometown.
Yep.
Yeah.
So, it's not that they're just focused on equipment at this point in time. Now, obviously, they've when you think of particularly football, most of what you're going to see is equipment. That's the thing with it. But obviously, there's a number of distinctive football players, where, like how they wear their hair is visible.
Facial features, eye
stuff
color,
like that. Yep.
A facial hair, Yeah, it was pretty faithful, but the names were not there. But one feature the game did have is you could download rosters from online. You could also update the names of the players in the game once you bought it, and you could export. Yeah, you could export the roster online. So what happens every year? Somebody goes in to their favorite team and just adds all the correct names, exports the roster, puts it on a sharing website. Everybody downloads it, and voila, we've all kind of worked around the issue. Aren't we so clever?
Yeah, exactly.
Well. We were so clever for a long time. This worked for 20 years until in 2013, two players, the main plaintiffs were named Ed O'Bannon and Sam Keller. O'Bannon was actually not a football player, was a UCLA basketball player. And Keller was a former Arizona State and I think Nebraska player. Anyway, so there was a college basketball version too of this, which I don't think was nearly as successful, but had all the same issues.
Yeah, but I mean, there's every sport basically has these. I mean, there's amateur versions, there's college versions of them, and there's professional versions of virtually every sport. Like I comment, I played the NASCAR version for car racing, so. Mm-hmm.
The issues are a little simpler there, I think, because it's professional. It's easier to get a license from NASCAR.
And that's a key thing to keep in mind with this, is that EA also puts out professional games, based upon the professional sports. There are specific organizations, maybe the Players Union, that is licensing players' likenesses, everything along those lines. So none of the issues we're going to talk about in this basically exist when it comes to the professional games, because there's an organization that basically says they can be paid for this, they are paid for it, it is a job, and therefore sort of this whole thing goes away. One of the real keys about this is for amateur players, for players that are in college where there's a very particular requirement that they can't be paid.
Yeah, and that's going to wind up being the nut of all of this is the NCAA's involvement in this. So anyway, O'Bannon and Keller filed a class action lawsuit against the NCAA itself, against EA, and also against the Collegiate Licensing Organization for using their likenesses without permission and saying it was a violation of the right of publicity. At this point, we should probably explain what is a right right of publicity and why do we have it?
We talked about it a little bit previously in conjunction with this, but the right of publicity is basically that sort of every person, now it's primarily important for famous people, but it does actually apply for every person. Every person has essentially the right to not be misrepresented as themselves.
It's to control the commercial use of your personality, your identity, your appearance.
Yeah, the commercial use of it. So the example would be is it's if you're going to go out and somebody's going to say, hey, it turns out Ben Siders really, really loves this brand of toilet paper. Mm-hmm. He's got to be compensated for that, even because the idea behind it is
my
that
licensing fees are substantial.
Yeah, you can't just say that, even if it's true. You can't just say that because it's commercial use of my co-host's personality in a way he didn't approve of. And so it's kind of this idea that says, hey, I get to approve of somebody using it. The example I always use is right of publicity, and I actually think it's one of the bases of rights of publicity, even though it's not directly publicity. If you ever encounter products which are sold in England, a lot of times one of the things you'll encounter is a number of them have the royal crest on them, and they say by the order of Her Majesty the Queen, whatever it is, that this is something which is served, at various royal functions. You're not allowed to put that on unless it's true. And basically, it's only true if the Queen tells you it's true. And so that's a little bit of sort of the core of rights of publicity. But this is much more saying, as opposed to it being a crest or a representation or a trademark, the person has the right of publicity in themselves. And what that usually comes down to is what is themselves, and most commonly what it's associated with is their name.
Usually, yeah.
Usually their name is what it is, something to identify them. We talk a lot of times, and you encountered in other areas of law, you encountered in HIPAA and healthcare, you encountered in the new sort of, Data Protection Acts. There's a lot of this idea of identifying information.
Yep.
And the vast majority of people, when they say identifying information, the name is obvious. Yep. A name is an obvious piece of identifying information.
But it can
as
also
is
just
an
be
appearance.
sort of invoking your general personality and identity. And the classic example is the Vanna White robot commercial.
Yes. And what you basically bump into in conjunction with that is the idea that sort of says, hey, some people, and again, a lot of times when you're talking about these, you're talking about famous people because they're almost recognized as archetypes, so to speak. So the idea is, Vanna White in turning the letters of Wheel of Fortune was so well known that even making something which, is a robot designed to turn these figures could potentially violate a right of publicity, even though it's clearly not her. It's clearly intended to be her.
Yeah.
Whether as a parody or whether as sort of direct representation.
You're invoking her. You want people who look at that to think of her.
Yeah.
And maybe it's the juxtaposition of the blonde android, that makes it interesting or funny, but the bottom line is you're talking about Vanna White, whether you use her name or even her picture or not.
And there's a lot of stuff in life to publicity that basically, and again, a lot of the thing with rights to publicity is to basically say, like, I should be able to say that I shouldn't be associated with something. I don't necessarily want to be associated with a product I don't want to be associated with. If you want me to be associated with your product, I have to sign up for it and agree. Now, some parties may very well be willing to sign up for anything, but others are definitely more controlling. I think a lot of people are going to be more controlling. They're going to say, hey, I don't want to be associated with this product. I don't care how much you're going to pay me. I'm not going to sponsor your product.
We should also say it's election day as we're recording this today.
Yes.
So there are some exceptions to this rule, though, for people who are famous and particularly famous in politics. There is a First Amendment limitation to the right of publicity, which is why every political PAC commercial you've ever seen always shows the evil candidate in slow motion, black and white, grainy footage, accompanied by dark, slow violin music, and then followed by the bright, happy color footage of the candidate you're supposed to like, walking upright and not slouched over. Do you see how you're being manipulated, people?
Yeah, exactly. But I think the thing about it is it's a lot of times what's referred to as the newsworthy exception.
Yes.
And so basically there's a recognition.
It's a public interest exception.
Yeah, there's a public interest that, anybody who is newsworthy, we need to be able to provide news without compensating them. Because obviously otherwise, we would have far more fake news than we definitely do today, regardless of how much fake news you think there is today.
It's almost like a fair use type analysis, basically. It's like the Republic won't function if we can't do this.
It kind of is. I mean, I think the real behind it is, and the idea behind the newsworthy is, you shouldn't be able to stop. A lot of the idea behind right of publicity is that I can stop you from associating me with something I don't want to be associated with. But if my being associated with that is newsworthy and something people know about, I shouldn't be able to stop that.
Particularly if I'm just showing things that actually happen. You know? Assuming I can get a copyright to the actual footage of it, the people that happen to be in it, if I'm doing it for news reporting type purposes to convey factual information or educational information to people, it seems like a pretty clear public policy interest, and we should be able to do
And
this.
something we're not going to get into in this show, but it's worth pointing pointing out, especially if we get Charla back in here, she does a great example in conjunction with it. There's a lot of problems right now in right of publicity associated with social media. And literally what is newsworthy, sort of what is not newsworthy. When a celebrity gets a candid photo taken, and what is shown in that photo suddenly becomes valuable to somebody.
Particularly when what they're doing is not a matter of public interest, or maybe in you and me, our reckoning, should not be. Like, there was one case, we'll have Charlotte talk about it, where an actress walked out of a pharmacy, like, wearing sunglasses, not dressed to attract any attention, trying to just go about her everyday business with a couple of bags of goods, and some paparazzi took a picture of her and put it online.
Yep.
Well, she happens to have a promotional deal with a different pharmacy. So all of a sudden it is a matter of public interest that she's got a deal with pharmacy A and she's shopping at pharmacy B.
Or is it? And that's, I think, the thing you sort of bump into. And, again, I think this is just a little bit of a preview when we get Charla back in here again to talk about. These are thorny issues today, Dan. Right publicity used to be relatively easy.
Nobody cared.
Nobody cared, but it was also, right publicity was very confined.
Yeah.
Is it a TV ad? Is it a radio ad? Is it a newspaper ad? If it's none of these things, it doesn't matter anymore.
Yeah, and you also had somebody that served a filtering or screening function.
Yeah.
Does it go in the paper or not? Well, we're going to talk to the photographer. We're going to get clearances. We're going to make sure that it meets the newsworthiness, and it's the kind of thing that we would put in a newspaper with limited print space.
Yeah.
But on the internet, there's infinite print space. You can dump as much garbage as you want out there.
Yeah, and so I think that's the thing. And so I think that, from our point of view and sort of, with this topic, there is a newsworthiness exception here. It's just an example of, to use a simple example of things like the NCAA. Obviously, you can show in a news report, sports segment of a news report, here's the highlight from the film that obviously shows a player scoring a touchdown, and it's obvious which player it is.
You can use their names. You can talk about what happened. They threw 14 passes. They completed 12. I'm obviously talking about Iowa, since nobody throws a pass in the Iowa games. No, but I mean, you can report what actually happened during the game because it's news about an entertainment event.
Yep.
That's fine. You can do that. But this was not that. This was a video game, which is not the actual people doing this. And that's what the court said. The EA argued that they had a First Amendment right to use the likenesses in this way, and the Ninth Circuit did not buy it. They said, no, the similarities between the players and their game avatars was sufficient for the players to have rights of publicity in the avatars used by EA, that the changes were minimal, they were given the exact same context as the real-life counterparts, down to the equipment that they wore and where they're from. And so, EA lost. And there was a settlement of the class action for $60 million, of which each player involved got about 1,200 hours, which, that's not bad.
Yeah,
considering how many copies were sold, and they didn't have to do anything they weren't already doing. So each player got 1,200 hours, but there was 29,000 athletes that were involved and projected by this. And then, of course, the attorneys got their fair share, which was $18.8 million. Seems fair?
Yeah, of course.
Yeah, of course, yeah. So it's a result.
Can you tell which side it is? We are not the sports stars. We are the attorneys. Yeah,
that's class action bar. So as a result of this case, EA could not make the games unless they paid the players for their likeness rights. Seems fair, doesn't it?
Yeah, I mean and that seems to be the outcome of what we expect from this. Is that hey, yes, these are clearly these players.
Yeah.
Yes, they weren't using the names, but they were using pretty much everything else. Are they identifiable? Of course they are.
Yeah.
It seems like this would be the logical place that you would go in likeness rights.
EA agreed. They said several times they'd pay the players, especially at the rate that was calculated, and as well as these games sold. If you don't know, college football is a big deal, even bigger now than it was back when this went on. It's a huge moneymaker, more so every year. So EA said, sure, we'll pay them. And then we can actually add their names. It makes the game even more accurate. So, yeah, sounds great. But there's a problem.
Yep. And that's
NCAA.
There's the rub.
NCAA said, no, you can't do that because if the players make any money during school from their identity rights or they're otherwise paid in connection with their performance on collegiate sports teams, then they're no longer eligible to play at all. They lose their scholarships.
NCAA rules.
Yep, they're out. So.
And yeah, this is as I said, there's the rub. What we're bumping into here is, if this would have been professional athletes and we would have reached this point, with it, they would have paid the professional athletes whatever their asking rate was via the athletes union, and this would be over. The problem with it is that what you bumped into is EA Sports was now told in order to use this you have to pay them, and then on the other from the organization on the other side
the players
said
don't get paid.
You can't pay them.
Yeah.
And the issue with it is it's not that EA violates any rules by paying them; it's that the player violates the rule by taking them. the payment.
EA could have gone around the NCAA entirely and said, fine, we're not going to license from you. We'll just go directly to every one of these football players. I mean, there's probably 1,000 or 2,000 Division I players.
There's 29,000 according to the payout.
Well, that's over the course of the whole time. For football, there's 120-some Division I teams, and each one's probably got 100 players, scholarship, and walk-on.
Yep.
So do the math, you're talking 10,000 players. It would be a hassle, but you could go do that. But the problem is the players can't accept the money because then they lose their scholarship.
Yep.
So EA canceled the game. Weirdly, though, this was not the end of it.
Yeah, and again, I think the fun thing to hear, and the thing I would really sort of point out in here, because I think it's a valuable thing to keep in mind, is EA canceled the game because they couldn't get the rights they needed, which they were completely and totally willing to pay market rates for. And this is the United States
and entitled
law
under
and
law to do. I mean, the
Yeah.
NCAA is not the government. They have no legislative authority over anybody. All they can do is set the conditions under which you are eligible to participate in NCAA athletics.
Yeah.
But since that's where all the money is, you don't have much choice.
So we literally have an organization here that is ready and willing to pay market rates for what it wishes to acquire.
And players who are willing to accept.
And players who are willing to accept.
Presumably.
And an organization sitting in the middle, which is the NCAA, saying we can't have this transaction. And again, I think one of the things we really want to hit on in this, the NCAA is not the government.
No.
This is not a government
It's a private organization
saying you can't do this. The government of the United States has said this transaction is completely allowed. The court has even said this is the transaction that's supposed to happen. The NCAA is a private organization, but what the NCAA basically does is say it's NCAA sports. There is a sports organization.
It's a standard-setting body for how these athletic competitions are going to be done with college athletics.
Yep. So what we have in this situation is basically willing buyer, willing seller, which is enough as the Music Modernization Act, reference here. So coming back in, we have willing buyer, willing seller, but we essentially have an organization sitting in the middle, which is a private organization, and that takes us to our next piece of this case.
So O'Bannon wasn't done yet. He then filed another lawsuit, another class action, saying that the NCAA's refusal to let the players license their identities was a violation of federal antitrust laws, the Sherman Act.
Yep.
So this is an interesting theory because normally the antitrust laws hold that there's two parts to it. One is the traditional Teddy Roosevelt trust busting thing where you can't have two companies get together and engage in price fixing.
Yep.
Which is a variation of this. This is a situation where they said the NCAA essentially is a monopoly over college athletics, and it has arbitrarily price fixed the value of collegiate players' likenesses at $0.
Yep. Now the other thing I think to keep in mind in conjunction with this is the NCAA is also not a union.
No.
So we look at this and say, hey, we've got the NFL. We've got, sort of all of the aspects in the NFL. There is a universal organization which holds all the rights to the players, likenesses, et cetera, in conjunction with the NFL. But that's a players' union, and that's acceptable because they've gone through all the various laws they have to be in order to be that. The NCAA isn't this. And I think that's where we're seeing this case now comes from. We've got this organization that sort of says, hey, there's all these ways that this can be done within the law that are well established, that are long running. It just so happens that in this situation, none of them apply.
Yeah, and in the NCAA case, I keep saying blurring AA together. I've heard people say NC2A, NCAA, NC whatever.
NCAA is common.
I just say NCAA. So what's interesting is that the NCAA, I mean, it is, as it says, the National Collegiate Athletic Association. I think that's what it stands for.
Yep.
But it's kind of like the NFL. The NFL is a league of team owners, essentially, who agree to compete in a certain way. The NCAA is the same thing for universities. And the court in this case agreed that through the NCAA, the member universities had collectively agreed to a price-fixing scheme as to the value of the likenesses of players playing sports for them. The court found that the players had a market, obviously, for their identities, and that it was being improperly restricted, and that there were less restrictive alternatives to satisfy what the NCAA wanted to do. So the district court, the trial court, ordered that the scholarships be raised to cover the actual cost of attendance to the schools and to pay the players $5,000 per year in deferred compensation. Now, that last piece was removed later. Those of you who are sports fans will say, wait a minute, the players aren't getting paid. No, they're not. The Ninth Circuit upheld the finding that the NCAA was engaged in anti-competitive activity, and they upheld the cost of attendance requirement, but they reversed the $5,000 per year stipend as excessive and unnecessary, and found that it was not as effective at preserving amateurism as not allowing compensation. So that part was thrown out. So We're left in a quagmire now. You know, EA, anybody else, can't really make a game that really uses the teams as they are each year unless they pay these players, who would be happy to get paid, I'm sure. You know, the players are getting a little bit of a better deal, I guess. They're getting more through their scholarships now, but not everybody's on a scholarship. You have plenty of walk-ons, and they're usually going to be included in a game like this too. And so there's really no way for this game to get made right now. And this resulted in the immediate aftermath in a lot of criticism of the NCAA. And there was for a couple years, because I follow this stuff relatively closely as a sports fan, quite a bit of talk of, well, the day is coming when the players are going to start getting paid. But what really holds that back is you can't just pay the football players. You got to pay everybody. Yeah. We have Title IX, and you can't prefer football or basketball over volleyball or anything else. Yep. And you can't prefer men's sports over women's sports. So whatever dollar amount they decide they're going to pay football players, they're all but required to pay the same amount to everybody.
Yeah, and I think that what we're really bumping into is, at least when it comes to, and I think for any of our foreign audience, when we're talking about football here, we're obviously talking about American football. Yeah. But what we're really seeing is American football at the college level, American basketball at the college level is on par in popularity with their professional counterparts, which is not true of essentially any other sport. I think professional baseball is vastly more popular than the college version is. Professional hockey is much more popular than the
There's virtually no market for college hockey.
Yeah, there's virtually no market for college
outside
hockey.
Outside the players and their family and a couple of dedicated fans.
And so what you really bump into is you get these huge markets for certain sports, but at the same time, you've got to kind of make the rules for whatever this is going to be across all sports to have it a fair playing field. You also have far more amateur sports than you have professional sports. You're going to have NCAA rules when it comes to things like swimming at the college level, which is, arguably accepted probably the very, very highest level, not professional, and even there probably isn't.
Well, in college, you've got golf, you've got lacrosse, men and women's field hockey. Yep. I'm from Iowa, so wrestling's a big deal. Tennis. There's a lot of sports, and this also plays out differently from school to school. So Iowa, my alma mater, has a decent number of sports. I don't know how many, but there's probably 12 to 14 men's and women's sports. But other schools don't do that. If you get to like a lot of the schools in the South that are more football centric, they may only have a half dozen sports for men and women, which means all the money can be funneled into football. So they can afford to pay this because they have fewer athletes on scholarship than a small public session, a relatively lightly funded public school like Iowa.
And I think we can also jump on this and we can also look at it and say, I think this is part of the reason the NCAA is so very defensive of the amateurism position. Is when you look at it and you say, hey, yes, there are these huge numbers of sports. Sports is a big learning activity at colleges,
in theory.
Many of whom are not making football teams that make it onto national TV. Mm-hmm. I didn't go to a Division I school, so it's one of those things where it's very easy for me to look at it and say, nobody cares who's on our
You're
football team.
You're the classic small liberal arts college guy.
It's one of those things that happens. But, it's the kind of thing where you look at it and, you sort of, you come to these things with it. The NCAA coming in and saying, you've got maybe 20 or 30 schools, which this is hugely important, which there's vast amounts of money in, and the rest of all college athletes are really sort of not in this. Yeah. We can't be catering towards those, 30 or whatever it is. 30 schools or whatever that number is.
You want the tail to wag the dog, although in this case it's more like the head wagging the dog, I guess. Because so these sports are big revenue generators. Yeah. Even at a school like Iowa, which is not historically an awesome program, still the football program alone pays for itself and every other sport on campus. Yeah. So it's a big deal, and there's a lot of money at stake.
And that's the thing with it is we're looking at there is a huge amount of money in this deal as to whatever it might be, and how do you deal with the fact that we have this huge amount of money in a very small percentage of these sports, and our goal of these sports is not supposed to be that these are for profit, but they have become so. And I think that's the question we're really wrestling with here, and it's not a question in some sense a legal question, it's almost a moral question that we sort of bump into.
It's a kind of policy question.
Is this game not being made because of the fact that we really do want to say it shouldn't be. As much as we can look at it and say there's a demand for it, that, people want this because they this is a semi-professional organization, we really looked at it and say, this game can't be made, and the reason this game can't be made is because it shouldn't be made.
And this issue is kind of unique to American college football, because I think it used to apply to basketball too, but probably doesn't so much anymore because so many kids just go straight from high school to the NBA now, or only play 1 year in basketball and get out.
Yeah.
But the NFL rules require you to play, in most instances, 2 years at least of college football or an equivalent before you're eligible for the NFL draft.
Yep.
So the American college system is effectively the farm league for the NFL. And so you have this amateurism rule and all these lines. There's so much money involved. It seems like those things are not accidents, that they happen together. And this issue right now is, seems to be unique to sports, but I don't think it's going to stay that way.
No.
It's going, it kind of already has bled out into other areas. We talked, I think, on one of our episodes about a Blizzard employee who recorded a Murloc sound for a Blizzard game.
Yep.
And after she left, she later, I think, filed a lawsuit or sought some sort of compensation for the use of her likeness.
That was the right publicity.
The right publicity case in the recording of that Murloc sound. And as games increasingly use, live action actors or motion capture, I could show you a movie that just has the motion capture of two different actors walking with like a wireframe, and I think for certain actors you would be able to tell who generated the motion capture just based on how they walk.
Yeah, there's definitely, some nature of what that is, and so much of it now is also even for facial actors doing animation, things like that. This is an area that's bleeding out of sports. We're looking at the idea of now saying, hey, You've got rights of publicity stuff where people can potentially be identified, and we're also seeing it in data protection. We're seeing right of publicity sort of becoming a more important thing, of the idea that says you need to have a right in your identity, I guess is the best way to put it. And somebody shouldn't be able to take your identity from you, shouldn't be able to do it. I mean, we talk about identity theft, that sort of, being a crime. And what I think we're really seeing in this is stuff like, how does this bleed over? And it's not a new problem. You definitely had this. I mean, you have issues with like model releases, going back 50 years, where, a model would allow pictures to be taken for use in certain companies' advertising. It may have been a limited license to how they could be used, what they could be used for. Back before they're famous, they become famous. Those pictures get sold to somebody else, get used in somebody else's advertising, and suddenly you end up with this kind of thing. And it's, but that's what the contract said could happen. But again, it never would have happened except for the fact that the underlying person became famous.
It's kind of a version of the song issue we talked about before, where you record or make some little ditty, and then it winds up going viral, and all of a sudden it's worth a ton. But since you didn't paper the record over in the first place with adequate documentation, and there's an economic inefficiency there. I mean, you're not going to go and draft these contracts for every last thing you do.
And amateurism becoming an issue.
Yeah. It definitely is.
And the reason I used to sort of amateur becoming easy is let's just talk about the music thing and the concept of YouTube. And you have artists who have made their names. I mean, just throw it out there, Kane Brown, in the country world, who's basically made his name as a YouTube artist and is now an extremely successful professional recording artist. Where you kind of look at it and say, he started off as an amateur. When did he cross over?
Yeah.
And so if we look at this and say there's an amateurism type of thing, we kind of look at this and say, yes, we want to protect amateurism. We want to let people sort of do this thing without it being paid, without it being compensated, without them having to be good at it, so to speak. I mean, and
sometimes that's what makes it entertaining.
Yeah, and sometimes that's the purpose of amateurism, is to really say, hey, yes, you should be allowed to play football, even if you're no good at it.
Yeah.
Because it's
sort of the B-movie version of sports.
Yeah, exactly. But we've really got that. I think it's one of these things you're really seeing becoming a big issue. And that's part of the reason I think we wanted to talk about it in this episode is I think right of publicity and sort of right and identity is something that's coming more and more important. Something we may very well touch on again later on this season, but we're really seeing in law right now this concept of ownership of yourself becoming a valuable thing and becoming a much more important thing, and the law struggling with how do we deal with this.
It really has been a struggle. When I was in law school, I did a summer doing research for one of my law professors, Neil Richards at WashU, who was really into data privacy issues and really on the cutting edge of this stuff. And there's at the time he was drafting a paper on it, and we were doing a lot of research into different conceptions of the legal sort of analytical framework for ownership of data about yourself. So you've got your personality is one thing, But what about all these data profiles that these companies develop of us based on our online behavior? They don't know who we are. We're just some number in a database. I mean, that's an identity, I suppose, but it's not a personally identifiable. They can't trace that back and say, this is Ben Siders. Or maybe they can in Cambridge. Yeah, so I mean, this issue is coming up more and more, and we're not really sure how to deal with it. Europe's kind of on the leading edge of this with GDPR. I've got my complaints and criticisms about how exactly they've done that, but they are doing something that can't be denied. And along these lines, is the same line drawing exercise with professionals versus amateurs going to creep up in other places? So I'm thinking of things like, setting aside regular sports, esports. We have other things where athletics are different because the level of physical investment and natural talent required to participate competitively, even at low collegiate levels, is 1,000 times more athletic, potential than this room has collectively. So neither Kirk nor I are going to play any college athletics, but we both play Hearthstone. We're both pretty smart, and if we played enough, we could potentially be competitive Hearthstone players, right?
And and there are players of huge numbers of online games. I mean, Fortnite. Let's just talk about that one briefly. Which are paid large amounts of money for their ability to play video games.
So do you have a risk at some point, or just like, what about college students who are on music scholarships and they start putting stuff out on YouTube? There's no NCAA governing music scholarships, so it's not quite the same issue. There's no amateurism issue. But then that goes back to, do we even need an NCAA anymore?
Yeah. Well, let's get really geeky. What about the math team?
Yeah.
Or the chess team?
Or the chess team.
I mean, the chess team is a good example because we're starting to see competitive chess becoming a little more mainstream.
And you've seen talk of chess and things like that becoming maybe Olympic-level competitions.
Yeah. And so you kind of bump into that. Wait a minute, is there another question between where's amateur and where's professional? And I always remembered it. I always learned that amateurs weren't paid, professionals were. That was the dividing line. What we're really seeing now is the fact that it's not clear where that lies, because it's not like you're necessarily being paid directly anymore. And again, this is where I think YouTube is a great example. If I'm putting advertising revenue up on my own YouTube stream, I'm not technically being directly paid. Mm-hmm. I'm being I'm being paid based upon just hits, based upon sort of the fact that I happen to be popular. The advertiser doesn't necessarily know that that's me, that's generating those hits, but that's what's generating those hits. They're just paying for hits. And so it's a really interesting thing where I think you get into this now where we've really seen a sort of smashing up of revenue models. We've seen a smashing up of the idea of identity, recognizing that right of publicity, when sort of these laws were all written and all created, was very, very particular. Was it a TV ad? Was it a radio ad? Was it a print ad?
The issues were simpler.
It was much simpler and easier to define. Now we're really bumping into the fact that we're saying, hey, you can have a publicity which isn't involved in an ad because ads may be associated with it. What does it mean to be professional? What does it mean to not be professional? Anybody can put ads in their own stuff. People will pay people to put ads in their own stuff. Where is this going? And I think that's the thing we've really seen with it. Again, I think that's, to recognize we just scratched the surface here. We talked about one particularly interesting case. And I think, it is an interesting case, and it's an interesting case for what may happen in the future.
It's interesting in part because it got litigated twice over two different issues. These kind of things often get, papered over and solved and wrapped up in a way that does not require or sometimes specifically avoids a judge ever issuing a decision on it. Because we've talked before, sometimes people don't actually want answers to these questions.
I think the other thing with it is that you also have, again, sort of treating these things is we really have three parties here that are involved, and really more than three parties, but three direct parties, where their interests are all at odds with each other. And basically the court cases, you see two of them going after each other. And again, that's why I sort of mentioned that, in most scenarios, had the end of the first case of this, the second one never would have happened. Mm-hmm. Because everybody was willing to agree with what was happening in the first case. Quite frankly, the first case never would have gone to trial because this just would have been willing buyer, willing seller. There would have been a contract. This would have been over. But you bumped into the fact that basically we couldn't do this thing that everybody wanted to do. You almost kind of look at it and say the two parties in the first case were almost on the same page with each other. They almost weren't disagreeing. They were, because they had to. But they kind of weren't disagreeing what they wanted the law to be.
Players were telling EA, you need to pay us. And EA basically said at the end, we will.
Yeah.
But they couldn't.
Yeah.
It's such a bizarre situation.
It really is a bizarre situation. And just to sort of follow up, you mentioned this fact that, there may be some more of this in the future.
Well, yeah, and it's kind of a version of something we've talked about before, which is that a lot of our laws, laws tend to be, more and more I conceive of the laws as B2B or B2C. Are they business-to-business laws that are meant to regulate commerce between sophisticated, capable actors, or are they remedial or consumer protection laws meant to prevent, people who can't advocate for themselves from being taken advantage of? And, the Copyright Act we've mentioned before, the nature of the remedies and the rights is not really designed for, the music industry, for example, to go sue people who are pirating software. It was meant to prevent other music companies from pirating their software, companies that can actually afford to pay $150 million, or $150,000 in statutory damages. But what good does that big, heavy hammer do against, a single mother in Minneapolis?
Yeah.
Okay, so she downloaded 15 movies. Great, So you got a $2 million judgment. She's just going to declare bankruptcy. You're never going to collect it. So we do see the law sort of, if not necessarily in the letter, at least in practice, treating different groups of claimants or plaintiffs differently depending upon the purposes of the law, and defendants for that matter. And here we see again, there's a difference between being a professional athlete and an amateur athlete. But that, in this case, the instance doesn't really derive from legal requirements specifically. It's because you've got this private organization inserted into the amateur side, but its analog in the professional side doesn't impose this limitation.
Yeah. And again, part of the reason we look at that is because what they're doing is they're imposing a moral or a policy limitation, which really, the law is not designed to regulate. It will do it when it's told this is what the outcome is supposed to be.
Congress could come out and say, we are going to forbid any public university that receives federal funding from participating in the NCAA or any of its activities.
Note that receives federal funding. Yes. We need a Commerce Clause.
Yeah, so USC, actually, all the private schools will still be in there. They still do. That's going to be their jurisdictional hook. We forbid you from participating until and unless X, and X will be whatever compensation arrangements they want to have for the student athletes. Congress could step in and fix this, and really a state could too. I mean, these schools get funding from the state, so all it would take is Texas to step up and say, nope, we're not doing it anymore. But it wouldn't be Texas; it'd have to be Alabama because that's what everybody cares about now.
Well, I think any one of them could do it.
Yeah.
But the other thing I think you see with this, and you mentioned this, is it may not be the end for college football games. And we may see football games coming out, which now look like college football games, but don't necessarily look like players.
Yeah, so there is a game that's, I think, coming out called Gridiron Champions. It's supposed to come out in 2020. That's supposed to fill this void, and they're going to get around this likeness rights issue by just having the players all be generic teams, generic players. Then they don't need licenses from the schools. But I will not be at all surprised if, when this comes out, there is a team located in Johnson County, Iowa, that happens to wear black and gold, and then you can get third-party download packs and skins produced by others who are not associated with the game manufacturer that slap Iowa's logos on it, or insert your team of choice here. So.
Yep.
This may be just an even more roundabout way to do that. We'll have to kind of keep an eye on that and see what happens.
And I think the other thing about this is we've seen, it's not like this is new. I mean, I remember, I had it in television when I was a kid, and I mean, there was a football game, and if I remember correctly, it was red and blue, and they were home and visitor always. Like the one color was always home, one color was always visitor, and you always played home. That was the only option. Did you remember Double Dribble on the Nintendo, the original Nintendo? It was basically the Bulls, the Celtics, the Lakers, and somebody else. Yeah. I mean, it was a red team from Chicago. I mean, it was really obviously the same teams. I forget. Yeah, but at the same time, I mean, the players were blocks. I mean, because that was the quality of the graphics. The animation was very bad. And so we're getting into again accuracy as to what it is. And I think the other thing with it is, just one that I think is fun to mention with this, we're talking about rights of publicity here, especially for American football. Players are identified by their equipment. And we're really looking at the idea that says, if you can, in many respects, make a football player that's literally empty equipment. It's just the helmet, the jersey, things like that. There's no person in it. But the fact is that would still potentially be identifiable because of number, because of particular logos and colors of the teams. This is probably only going to get more interesting. Yeah, it's definitely not going to get less. I mean, and there's other considerations too with the TV networks and whatnot getting involved. So I think probably the next major shift, at least in college sports, as far as these rights go, is probably a ways off yet, maybe 5 years in the horizon, when the next set of TV contracts all get renegotiated, and we'll see if the money goes up or down. If it keeps going up at some point, this is more of a policy setting issue. But you talk to anybody who's involved on the fan level in college sports, and there's I've seen people
people who used to be very much against paying players have now said in the wake of these cases, there's so much money involved. These kids work so hard. I know they're getting a free education, and that's not nothing, certainly as much as college costs these days, but they deserve more. And people who I never thought would have said that are now coming around and saying these payers just need to get compensated. Now, whether that's because they just want to play EA NCAA football 2019 or not, I couldn't tell you. But,
yeah.
The public sentiment seems to be shifting on this, and if we know nothing else about a democracy, changes in law often follow. So we'll see what happens.
Yeah, we'll have to see where it goes.
Let's talk about what we're watching lately. We
try to put this in the TV show now. A lot of people have commented about the fact of wanting us to talk a little bit about sort of just what we're encountering in geek culture. So what's this portion of the episode?
So I've got a couple non-geeky things I've been watching that I won't get into too much detail on. My wife and I like Ray Donovan and Shameless. We've been watching those. I went to watch the new episode of Ray Donovan last night and promptly fell asleep, not because it was boring, but because I was just tired. And then the new season of the last season of House of Cards is out. I watched the first episode. I couldn't. It's a very complicated show with a lot of characters, and they introduce new characters. And it's been so long since the last season, I kind of forgot what happened.
Yeah. So
I'm kind of having trouble following it, but it's interesting. And then weirdly, all of a sudden, my kids are super into Harry Potter.
Actually, so are mine.
I tried to get them into Harry Potter for years and years, and they didn't care. And then this year is the year they're super into it.
Now, there has been some new movies in the universe. I mean, they're not necessarily Harry Potter movies.
I haven't seen those or even asked about them. Like they've been watching just the original movies over and over. Yeah. I've been asked probably 50 times in the last week, can we go get Harry Potter 6?
Yeah.
It's the only one I don't have. I have 7. I don't know why I don't have 6, but I don't.
I think I only have through 5. I don't think I actually managed to acquire the last 2 when they came out. But
I've not seen the last 2. I've seen the first 6 at some point. I read the first 5 books. I saw the first 6 movies, and I guess at some point I should finish that up.
I think I read the first book, and I think I've seen the first 3 or 4 movies.
All right. I've also got on my slate with the kids. We're going to watch Star Wars, like the whole thing. Because they actually have not seen the original movies, like beginning to end, and sat down and done it. But I think we're going to I'm going to try Machete Order on them.
So I actually did Machete Order on my kids, which they were a little confused by, just as what I did bump into. What's interesting is the movies that they've liked in conjunction with it. So my son really adores Return of the Jedi.
Mm-hmm. That was my favorite when I was a kid.
Yeah, it definitely is to
before I knew better.
My daughter really doesn't like any of the Star Wars. She just does not like the lightsaber battles. She finds them, I think, too brutal.
I thought they were boring when I was
actually
a kid. That was the least interesting part to me.
Yeah, I find them very interesting though. She thinks they're brutal because they're they are brutal. I mean, people get their heads and our hands and everything else cut off, but they're very bloodless, and I think it's a very interesting thing. And we've been watching a lot of Clone Wars. We're almost through the first season of Clone Wars, and again, like my daughter has no interest in watching it. She really doesn't like the episodes. Mm-hmm. The last time we watched an episode, she just wanted to go read and read her book instead because again, she's like, there's going to be lightsaber battles.
Yep. We should explain what Machete Order is. Star Wars has the problem that a lot of sagas have, which is the internally chronologically consistent order of events does not match the publication order. Like Chronicles of Narnia has the same problem. And so there's always the question, should you watch in publication order or in chronological order? And I'm a purist, so I always go with publication order. Watch in order they were made, and they will make the most sense, or at least, if they don't, it's due to poor filmmaking.
Which is the problem with the Star Wars movies.
But a lot of people don't agree with that, and part of the problem is I can't go back and do it the other way now. Like, it's impossible, because I remember the other ones. And the idea behind Machete Order is both of those are wrong, and there is a correct way to watch Star Wars, and it is to watch 4 and 5, and then go back and watch 2 and 3, and then watch 6.
Right? Actually, I think you watch 4, then 4, then 2, then 2.
You had to
3,
watch 5 because the end of 5, Vader says, "I am your father,"
that's right.
and you don't know if it's true yet if you haven't seen it. So then you go watch 2 and 3 because neither 2 and until the very end of 3 is it revealed is that true or not.
Yep.
Although we all already know because we've seen 6.
Yep.
And you'll notice episode 1 is missing because you just don't need it.
Well, we did watch episode 1, and actually my kids enjoyed episode 1. That's what it is. They really enjoyed. Actually, they enjoyed episode 6, I think, more than anything else. They also, quite frankly, enjoyed episode 3, which I thought was kind of interesting.
It's the best of the prequels.
It's the best of the prequels, but I thought it was interesting that was one of their more, desired ones. Yeah. I think the problem you bump into with the Star Wars trilogy as a whole is also for all of us, we remember not knowing who Luke's father was.
Yes.
And really, is this true or not? And we needed another movie to resolve it. Mm-hmm. There's no way to do that now. It's the same way as it's and I joke about it, is the other great one, and I remember this from when I was a kid and my parents, who shot JR?
Yeah.
we all know who shot JR. We probably don't remember because like that one's kind of fallen out of the public consciousness. But at the same time, it's one of those things like there was a time when nobody knew. And I mean, the start of the next season was going to be such a huge thing. I remember it being like all the TV guides, all the newspapers talking about what's it going to be, speculating about it. That just doesn't exist. You can go back and you can watch the show now, and none of that exists because we all know the answer to the equation.
I think it was Edgar Allan Poe that had this idea that what you aren't told is way more interesting than what you are.
Yeah.
And a lot of his stories were based upon setting up a situation that the resolution might be terrifying, but he never tells you what happens. So you just have to think about it.
Yeah,
and it's scary.
H.P. Lovecraft actually did a lot of that too.
Yeah.
If I remember right. That was his thing he was sort of known for. Is this thing just exists and we don't really know what it is or what it is, but it's vastly more powerful than we can comprehend.
The Jaws rule. Don't show the shark, right?
Yeah.
If you can't see it, it's much more terrifying.
Exactly. Yeah.
Let's see, what else? Recent movies, we saw The Incredibles 2, which I don't remember that well now because I was managing all of my
my kids saw The Incredibles
children.
2. I haven't seen it, but
it was good. My wife and I saw Deadpool 2. Did you see it?
I saw Deadpool 2, yep.
Did we talk about this already?
We haven't talked about it on the show. I don't think we may have talked about it on the show. I can't
There's
remember.
only so much we can really say about Deadpool 2 to not have our iTunes rating become inappropriate. Suffice it to say, it was a lot like Deadpool 1 in every way you would expect it to be.
The only problem I had with Deadpool 2 is I truly thought, I think in this way I may have said this, like, I think Deadpool 2 had too much plot. And I very rarely would say that about a movie. But Deadpool 2 really does have a pretty complicated plot, which really doesn't fit with what the Deadpool movies are.
Fortunately, they managed to mostly destroy the plot, so it doesn't wind up mattering. But. And then one that I have here for honorable mention, we didn't actually see this in the theater, but it's out on Netflix now. I don't know how my kids are watching it.
My kids did see it in the theater, actually.
Hotel Transylvania 3, which I only want to mention. I haven't seen the whole thing. I've just seen this one scene. And if you haven't seen it, just think about this scene in isolation and how absurd this is. Okay, so spoiler alerts if you haven't seen Hotel Transylvania 3 and don't want the ending to be ruined. And trust me, this will not ruin it. So I don't know what the plot of this movie is, other than at the point where I watched, and it's got Adam Sandler as the voice of Dracula and a bunch of other people. At the point I tuned into this, the main characters have to dance the Macarena to prevent a giant malevolent squid being controlled by Van Helsing, who is now an evil steampunk robot DJ, from destroying Atlantis. And the monsters are all in Atlantis because they were brought there on a giant cruise ship piloted by Van Helsing's granddaughter who's trying to get revenge on Dracula for some reason. Okay? So absorb that information.
Van Helsing and Dracula needed to have revenge.
I get that. But then absorb that information, and then this following tidbit, this movie made $700 million.
Well, and I think it says, some of the things with it. At the same time, we can also look at it and say that's almost such an absurd description. It probably is a good movie.
Well, this is like someone did a Mad Lib to put together a plot.
Which actually my kids are talking about things my kids are super into right now. My kids are super into Mad Libs right now and having a lot of fun with them. And they've gotten into the level of like trying to pick the words that sort of least fit what the theme's going to be. So like we just did the one that was, going to the bakery. And of course, so everything was what adjectives can we come up with that's something you would least want to encounter at the bakery, which does make the Mad Lib hilarious, admittedly.
Mine haven't gotten into that yet. I should probably give them a try on it. The last time we did those, it was all just toilet humor stuff. Which,
we have a bit of that problem too, but they've gotten, now they're starting to realize they're funnier if they don't.
Mm-hmm.
So
that's good. Anything else you guys are watching?
That's really it. I'm just not a consumer of TV for the most part. It's what it was. Haven't seen really any movies recently either. Just been, working too hard and things like that. A lot of it's also I'm still playing a lot of video games. I got super into the Mad games in World of Tanks Blitz. So those of you who don't know, one of my big games is World of Tanks Blitz. I loved the concept. I played them aggressively for like 2 days and then got so fed up with not being able to figure out what to play. Mm-hmm. And like people obviously knowing more which tanks to control, I stopped playing the Mad games. But I still I loved the concept of it. I thought the videos that they did to support it were just hilarious. And sort of the way they played around with, you don't need a truck, you need a tank. And stuff like that. But yes, I've definitely played a lot of that, played a lot of Hearthstone. I'm still playing a lot of Pokemon Go, which, is kind of a pain because I can't necessarily get out and walk around as much as I need to.
It's harder.
To do it aggressively.
What was the one flying thing that was always at our office? You used to always be able to catch them from our office.
Zubats originally was the thing originally. That was very early in the game. Yeah. It's we do actually have a spawner that's in our office building, but it's strange sometimes what it spawns. So
your side of the building gets poor Wi-Fi. Mine doesn't.
Yeah, definitely I get poor Wi-Fi on my side of the building.
Speaking of video games, there's a Hearthstone expansion that was announced last week. Looks like usual goofy Hearthstone stuff. I'm excited for that. I'm bored with the meta.
I think we're both bored with the meta in Hearthstone right now, and it's we both of us have commented about the deck we really love playing. If you know anything about Hearthstone, is the Mechathune deck. I love playing Mechathune just because
it's basically a deck that allows you to not play the game the way that it's supposed to be played. Normally, you try to beat your opponent by doing enough damage to take their hit points down.
Before you run out of cards.
Before you run out of cards. This deck, you don't. You try to run out of cards and then get down to one card and play it. And you win.
And you win the game. And it's a really interesting sort of thing with it. But I think the problem you bumped into is it seems like the metas, we were commenting about this, is it's gotten very stuck. Of just it's
the same.
There's
4
two
or 5
ways to
decks.
there's the same 4 or 5 decks, and the problem with it is they're unfortunately well balanced.
It's very paper, rock,
A beats B, B beats C, C beats D, and D beats A, and so you bump into have to play one of these 4, but yet the other 3 will beat you in accordance.
It's the meta we always thought we wanted until we got it. Now we realize it's incredibly dull.
Yeah, exactly. So that's what I think we've seen.
All right. Well, I think that's it for this time. So next episode, we're still working on bringing in some guests. And we have a large number of topics. Kirk and I sat down, I think, last week and kind of just brainstormed a bunch of ideas. So here's what we're looking at doing in no particular order. Data privacy issues, and then we've got ideas on video games, emulation software, mashups, something on music, anime, tabletop RPGs, maybe something with Mystery Science Theater, cult classics, fan-generated content, white hat hacking, and one that we're really excited about, horror movies, in particular the Rocky Horror Picture Show, and all of the crowd participation stuff that goes with that.
A little bit of the cult classics sort of coming in there too. But I think part of that is cult classics, horror movies, some of these things as we're talking about, is the idea of crowd participation events. And being part of it, and I think the Rocky Horror Picture Show being one of those for any of you guys who are seriously into that.
Particularly where the memes sort of generate organically from the audience, and then does anybody own that or not? Like, can I just go publish a script of all those things? And people have, and you can download scripts to take with you, and along with your newspaper and your toast.
Exactly.
If you haven't seen the Rocky Horror Picture Show or don't know what I'm talking about, just Google it.
just Google
it. Not at work. Just Google it.
Yeah, that's definitely a not safe for work thing.
I mean,
and your best stuff on YouTube.
It's pretty tame by modern standards. And then we're also trying to find some way to talk about Game of Thrones more, but I think that comes out this spring. So
it might be, yeah. And the problem we bump into there is Ben is an advocate of watching the TV shows, and I'm an advocate of the books.
I've not read the books yet. I probably should. All right. So there's the music, and it is time to go. If you have questions, comments, topic ideas, criticisms, complaints, remarks, adulations, or rants, you can send your thoughts to us on Twitter at LGGpod or email us at lggpodcast@gmail.com. You can also talk to us on our Facebook page, search for Lawyer's Guide to the Galaxy, and find us there. Subscribe to this podcast on one or more of the platforms, or even better, all of the platforms to artificially inflate our listening numbers. We are on iTunes, SoundCloud, Spotify, and all the other places where you get your podcasts. If you like what you hear, give us a review. Reviews are how we attract more listeners and grow the brand by making it easier for others to find us. Speaking of finding us, I am on Twitter at Benjamin Siders, and Kirk is at KirkDMN. Yes, I said that right. Yep. Thanks. That's all for today. We'll see you next time. Lauren, play us out.
The views expressed by the participants of this program are their own and do not represent the views of, nor are they endorsed by Lewis Rice LLC, its officers, directors, employees, agents, representatives, shareholders, and subsidiaries. None of the content should be considered legal advice. As always, consult a lawyer. This podcast was produced and recorded at Cool Fire Studios in St. Louis, Missouri.